Welcome everyone. My name is Andrew. I'm the owner of Ibis Prep, and today we are continuing our lecture series on the Florida bar exam. This is the 7th of 8 sessions, and the 8 sessions are actually split up further into morning and afternoon sessions. So this is the morning substantive lecture review. And even before we started recording, the class and I went over the material from last week, which was Florida evidence, Florida criminal procedure, and Florida civil procedure. Does anyone in the room have anything interesting that they learned or reinforced this morning that would be good for everyone to know? I know, Joel, you got me with something about Florida evidence. What's one of the distinctions from Florida?
All right, so like learned treatises in Florida, they won't be allowed in as substantive evidence, where in federal they would be. However, in Florida, they will be allowed where they've been proven to be authoritative already. They will be allowed to impeach a expert witness on cross-examination.
Excellent. Does anyone else remember any distinctions from Florida evidence?
Opinions, generally no opinion evidence is allowed in Florida.
That's good. And what about Florida civil or criminal procedure? Is there any interesting fact that the world should know? It doesn't have to be interesting. What's just cold, hard fact? What is a motion for judgment as a matter of law called in Florida?
So that's a directed verdict.
Directed verdict. Excellent. And what about criminal procedure? Anyone else know anything interesting at all about criminal procedure that we just talked about? Maybe the dates you have, or sheer silence?
Yeah, I'll give you one. So with the speedy trial, when you make the demand for speedy trial, you'll have 50 days to be brought to trial. And when you don't make the actual demand for speedy trial, you still have the right to speedy trial. So for misdemeanors, you'll have 90 days from the arrest to be brought to trial. For felonies, it'll be 175 days. If there's a felony and a misdemeanor combined, it'll be treated under the felony rule, so it's still 175 days. And for both the demand or no demand, when the expiration of those days passes, you make a demand for expiration of speedy trial. And if you're still not brought to court, you will be dismissed with prejudice.
Excellent. And for those who want to know about our hiring process at Ibis Prep, usually we just pick the cream of the crop from last year's class. So we definitely have a submission for July, but good stuff, man. So we spent the first part of class talking about evidence, Florida Crim Pro, Florida Civ Pro. Now we have to move over to business entities. I was a little bit surprised when I asked the class if they were excited for business entities, and they said no, business entities is not a very exciting subject. And the reason why I mostly disagree is because it's money talk, right? Everyone, that's all you really talk about when you're not studying or you're not like in school. You know, people always want to talk about their careers and how to make more money. And the way that most people have made money in this universe is through investments. And so understanding business entities will help you as an investor. So throughout your career, if you're making money as a lawyer, hopefully you could use that money to invest and earn more money, right? So the more you know about corporate structure, the difference between partnerships, corporations, and different laws that apply is actually good knowledge to have. It'll help you in conversations outside of just the legal practice. So while it might not be the best subject for lawyers who just want to argue with people, it is a good subject for people who are interested in having successful careers and want to know more about the businesses that they work for and the investments that may be made. So I'm going to do the general approach that I have to teaching, which is thoroughness. We're going to open up the folder and see what's involved. Business entities is tested as a multiple choice subject. There's only a 50% chance that it's going to be tested. Before I even jump into this PowerPoint, I know I said I'd start with business entities, but I want to pull up this one Will's PowerPoint because it has the first slide I wanted to use, which is this. The Florida multiple choice part of the exam. 100 multiple choice questions in 3 hours, the afternoon session. Most people will admit that it's the hardest part of the exam because they're the least prepared for it and it's just tough. There's not that many materials. Wow, that was easy, said no one ever, right? It's a very tough test. The Florida Rules of Civil Procedure, the Florida Rules of Criminal Procedure, and the Rules of Judicial Administration make up one segment of the exam, 33 to 34 questions total. The Florida Rules of Florida Evidence are often tested as the multiple choice for the other third of the exam. And then the remaining third is historically chosen between Florida Wills and Administration of Estates or business entities. So what does that mean from a study perspective? It means that besides Florida ethics, this is the only thing that's guaranteed to come up on the exam. Besides Florida constitutional law or constitutional law, Florida/federal con law, Florida evidence is like 90% or more likely to show up on the exam. So I would highly recommend you prioritize Florida crim law, Florida crim procedure, Florida civil procedure, Florida evidence, Florida con law, federal con law, and ethics. Those 6 subjects are coming at you on test day. The other ones you may or may not see. Today, we're going to do business entities and wills. From what the class has suggested, I think more people are rooting for wills. That's fair enough. I don't think that either Florida business entities or wills are like too bad. You know, I don't think they're great subjects, but I think if we learn the basics of them, then we'll be just fine. If you give me 1 second, I just clicked out of my place. So let's jump into the business entities presentation and hopefully learn a lot about business entities. For those of you who are interested in my company, Ibis Prep, we're an LLC. And honestly, if I could go back and do it over again, I would have been an S Corp. The reason for that is my business is growing. We're coming out with the mobile app. I have all these different departments. You know, eventually I'd like to go public. It's a lot easier to go public as an S Corp than an LLC. I mean, it's virtually impossible to go public as an LLC. So you want to be a corporation. The only real difference between an S Corp and an LLC, practically speaking, is the ability to have investors, shareholders. Yeah, so people in the group chat are talking about, is it going to be wills or business entities? I said there's about a 50% chance, right? But let's check it out. So we go to business entities, open up the folder, and I'll go into this PowerPoint. Some of these slides are more important than others. So that's why it's important you kind of listen and don't just go through the PowerPoint slide. So very basically, we want to understand the difference between partnerships and corporations, right? Partnerships are very loose. It's just like 2 people going into business together. Corporations are like Google or Meta, you know, like Home Depot, like Incorporated. Partnerships are composed of partners. There's unlimited liability. So, you know, it's me, I'm personally liable. I go in partners with Tommy, you know, I'm putting all my eggs in that basket. There's inequality in profits, management, and decisions. There's general, limited, and limited liability partnerships. For everyone out there, if you were ever going to join in a partnership, you'd like to be a limited partner. A limited partner is going to allow you to make money off the partnership, but without incurring the liability of being a general partner. A general partner is like the main person who's really handling everything and also incurring the most liability. So the similarities between a partnership and a corporation are they're both business structures that may be composed of more than two people. Now, a corporation is composed of shareholders instead of partners. Shareholders have limited liability, meaning if I invest in Google and Google goes bankrupt, well, they can't come after me for anything. I'm just going to lose my investment, right? There's not going to be any creditors coming after me and saying, hey, you owe us money. You're only limited to your investment. You don't have any personal liability. A corporation is a separate legal entity that earnings are generally through dividends. So you're literally creating a legal entity for tax purposes. That's why my company, Ibis Prep, is an LLC instead of just, I'm 100% owner. So instead of just a sole proprietorship, why do I create an LLC? So I can get some of these protections that corporations have by being a recognized entity under the law. So that's the purpose of being a corporation. You have this limited liability and you have, a separate, unique identity. So it's not going to be flow through taxation like a partnership. At a partnership, you're taxed at the individual level. A corporation is taxed on its own, and then they'll distribute those dividends to you after taxes. Now, you as an investor are going to have to pay capital gains taxes on those earnings. So that's why investing in a corporation, you do kind of subject yourself to double taxation because the corporate entity gets taxed and then you get taxed on your capital gains if you invested on it. So, there's considerations for it's like an outfit, a different outfit for every business. We kind of want to pick which outfit is best for this particular business. So that's the differences between corporations and partnerships. Corporations are separate entities that have limited liability. Partnerships are these individual agreements between people to conduct business that are going to have unlimited liability. Let's start with corporations. So corporations are usually like Inc. They have to have corp, co, or Inc. or the full versions, corporations, company, incorporated, Nike incorporated, Nike Inc. That has to be included in the articles of incorporation. The articles of incorporation are actually filed with the state. You want to incorporate, you have to file articles of incorporation. So what's going to be in the articles of incorporation? The street and mailing address, the number of authorized shares, preemptive rights, names and addresses of initially registered office and names of registered agent, and the name and address of each incorporator. So these are what's filed with the actual state. It helps shape personal assets from business liability. It requires separation of business and personal finances. It's allowable in all 50 states, preferred by outside investors, preferred for IPO, recognized outside the United States, a corporation. The difference between the articles of incorporation and the bylaws are more internal. The bylaws don't have to actually be filed with the state. They contain provisions for how the corporation should be managed and operated, and they must be consistent with the articles of incorporation and Florida and federal law. So the AOI, the articles of incorporation, are like, we're filing with the state, we're starting this corporation. The number of shares authorized means the total number of shares that the company is allowed to sell, right? If they're gonna sell more shares than authorized, they would have to go back and amend the corporate charter, the articles of incorporation. If you ever hear that word corporate charter, it's referring to the AOI, the articles of incorporation. They would have to amend that to authorize more shares. Just because they've authorized to sell 1 million shares doesn't mean that they have to sell those shares, right? Like when I go public, let's say, I'll probably sell 49% of my share. You probably will keep a majority or some amount of shares for yourselves. And we'll talk a little bit about what those shares might be called. But just at its inception, let's understand that corporations, unlike partnerships, must have articles of incorporation. There's ways to create a corporation without perfectly doing it, right? If you do it perfectly, then you're a de jure company. A de jure company refers to the legality of the entity and indicates that all requirements for properly forming a corporation in the state were fully met. A de jure corporation is fully incorporated. To be considered de jure, the company must have fulfilled all the statutory requirements for properly formed incorporation. Like soup de jure is a great company. You can have a de facto corporation. There must have been a good faith attempt to comply with the statute by the intended incorporators. Maybe there was inaccuracies with the filing of the articles of incorporation. However, a de facto corporation has been legally recognized, even if it's not filed as articles of incorporation. So like you tried to become a corporation, but you might have messed some things up, but we'll just consider you a de facto corporation. It was made in good faith. There were just actual errors. Then corporation by estoppel, and we'll see this come up with partnerships too. It's a common answer that like you're estopped from denying the corporate status, or you're bound by the partnership because of some sort of authority. Corporation by estoppel, and trust me, we see this word estoppel a lot. We see promissory estoppel come up in contracts. You're estopped from denying the validity of some contract or the execution of a contract. We see collateral estoppel, right? You're estopped from bringing that claim in. And here we see corporations by estoppel. You're estopped from denying the validity of a corporation. So estoppel occurs when a third party has dealt with the company on the basis and belief that the company is in fact a corporation. The third party is estopped from denying the corporation's corporate status. This is another common law doctrine designed to try and offer some degree of protection to the officers and shareholders of a corporation that was not properly established and cannot be considered either de jure or de facto. So again, why are we having these de facto or corporations by estoppel? The reason is to protect shareholders, right? If I invest in something and you're like, oh yeah, sorry, we're not a company, like, come on, you guys are stopped from denying that, or you're not gonna be able to claim just because you filed your articles of incorporation wrongly that you don't exist. Okay, I don't know why I always remember this meme that I've been using for years. One does not simply pierce the corporate veil. What is this from? Game of Thrones? This guy?
Lord of the Rings.
Lord of the Rings. Nice. Damn, I suck.
I think that was Ned Stark in Thrones.
Yeah, it's the same actor.
Oh,
really?
I think so. But I'm pretty sure this is from Lord of the Rings. I don't know his character's name.
You don't know his character's name? Could someone
He's like the guy who doesn't get along with who's the cool one? Aragorn, whatever.
Yeah, Aragorn's the guy with the
cool one with the sword. So he doesn't get along with him. That's all I know about Lord of the Rings.
I used to love those movies. When I was a kid, I saw them all in theater. I used to read the books, but I can't remember this dude. I definitely remember like Bilbo and the other people. What's the main character's name?
Boromir in Lord of the Rings.
That's him, Boromir?
Yeah, that's what I see right now.
And what was the main character's name? Bilbo's son? Because Bilbo's the Hobbit. Not his son, but like his little mentor. Frodo. All right. Anyway, the equitable doctrine of piercing the corporate veil allows judgment creditors to hold a corporation's owners personally liable for the corporation's debts. It can also refer to suing a parent company directly for the acts of a subsidiary. So what does that mean, piercing the corporate veil? This comes up a lot. It comes up like when there are shareholders who have acted, not shareholders, I'm sorry, when there are officers who have acted terribly, right? And we want to go after them directly. And they're trying to seek protection under the corporate status that, limited liability. Well, there are times when we can pierce the corporate veil and go after them individually. It could also mean what happens a lot in business, where a company creates a subsidiary just for the purpose of doing shady stuff, right? And if that's pretty much what happened, then we don't a lot of companies will create a subsidiary. That subsidiary they'll do risky stuff with, and then it'll lose all the money. And then, they'll have all these creditors and hey, sorry, can't touch us. That's just a subsidiary. They have nothing to do with us. And it's like, well, no, that was an alter ego of you. There was improper conduct and there was proximate cause. There's a book that we read first year of law school about two rivers and polluting the river and how they were able to pierce the corporate veil. I can't remember what it's called, the Buffalo Creek disaster. Actually, I think that's what it's called. It was all about this, piercing the corporate veil. Make sure you can understand these elements and prove these things. Anyone have any questions about piercing the corporate veil? We'll go over a little bit more in depth. I'm glad that we figured out this guy is so talented and movies and TV shows. So what are the characteristics of a corporation? Free transferability, perpetual existence, centralized management, and limited liability. I like that. C corps are taxed as an entity and subject to double taxation. Freely transferable. I buy a stock in Apple, I sell it to my buddy. Perpetual existence. Steve Jobs is not Apple. Apple will survive him. Ibis Prep will survive me, hopefully. Centralized management, right? It's like a board of directors, we usually call it. And a limited liability, meaning, like I said, unless you pierce the corporate veil, they're not going to be held personally responsible for these acts. S corps versus C corps. The purpose of electing to be a S corp is for flow through taxation, right? So an S corp is like a C corp that has limited liability, but it has flow through taxation, meaning you're taxed as an individual. Very similar to an LLC, but an LLC accomplishes kind of the opposite way. An LLC is like individual or group of individuals that elects to have limited liability, right? So you end up electing to have like the same protections, but like I said at the beginning of class, an S corp is more conducive to having selling shares. So C corp is taxed as a separate entity. Shareholders are not taxed. Shareholders pay income on payments from the corporation. C corp is always recognized by federal and state. S corp avoids double taxation, right, via flow through taxation. Corporation doesn't pay income tax. It can include losses. It's all about, flow through taxation, and it is recognized in Florida, so we don't need to worry about that. This thought I'm going to go through quickly. Authorized shares, remember, that's the stock that the company is authorized to sell in the corporate charter. Issued shares are shares that they actually sell. Treasury shares are shares that have been sold but then bought back to reprivatize. Outstanding shares are shares that remain out in the public. Why do investors buy common stock? For capital appreciation, growth of principal, right? You buy stock to common stock to have these rights. Common stock is when people say, I have stock in Apple. That's what you have, common stock. These are the rights that come with common stock. Voting rights. You may vote for the board of directors, stock splits, change of objectives and policies. You may vote by proxy, which is remote voting. That's just the term. If you see that term, by proxy. Votes can be straight or cumulative. They actually test this. They test this twice about straight versus cumulative. But straight versus cumulative voting, just remember this. Cumulative voting is designed to benefit the smaller investor. And the reason you have cumulative voting is so that you can vote all your votes for one person instead of having to vote one vote for a person. Straight voting is like you get one vote for chair. Say there's 3 chairs open. Straight voting, and say you have 100 votes, 100 chairs, and there's 3 chairs open. Straight voting, you get 33 votes per each chair. Cumulative voting, you could stack all 100 votes just for one chair. That's what cumulative voting means. Inspection rights, you get the rights to view the books and minutes of the company. Preemptive rights. So preemptive rights are anti-dilution rights, meaning that if the company is going to sell more shares than authorized, you have the right to maintain your proportional stake in the company. Let's say the company has, let's say Ibis Prep. We have 100 shares, right? And Joel owns 10%. He just got hired as a tutor and he got the sick package where he gave him 10% of the company. So he has 10 of those 100 shares. Now I say, you know what? We're going to authorize 100 more shares. Let's get this money, right? So now I have 200 shares total. Well, the preemptive right that Joel has is to buy 10 more shares so that he'll retain his 10% interest in the overall stock. That's what preemptive rights usually means. Derivative rights can refer to 2 different things. I'm just a lot of vocabulary. Most of the real, juicy, substantive stuff is going to come this afternoon during practice questions. I can't spin it any other way. I'm just trying to give everyone like an understanding of some terminology you might see. Derivative rights. This can refer to 2 different things. Derivative rights can refer to the right to sue on behalf of the company. Like, come on, you guys did some messed up stuff to Ibis Prep and made the stock go down. I'm suing you. Insert bad company. Or derivative rights can be the right to sue the company, right? Like, yo, Ibis Prep, you're doing bad stuff. I'm going to sue you. I'm an investor, right? So that's what derivative rights mean. And then junior liquidation priority. So we understand what liquidation means. The company is going bankrupt. When a company goes bankrupt, they have to pay off certain things. Let's just say let's not put that out there. Let's just say this juice company goes bankrupt. They're going to liquidate. The first people they have to pay off are their employees, right? You owe people money who worked for you. And you have to pay off Uncle Sam. Uncle Sam, the government taxes always going to come first. Then you got to think, what's the priority going to be? Well, security is an important thing. Secured debtors are going to get paid off first, right? People that lent the company money and they have a secured interest in it. Then unsecured debtors. Then creditors, right? People who have just the company owes money, right? And it's going to be that process of creditors. And then we get to equity owners, people who own stock in the company. But remember, preferred stock shareholders will get paid out before common stockholders. That's the main difference between preferred stock and common stock. In the order of liquidation, common stockholders have junior liquidation priority, meaning if the company goes bankrupt, you're going to get paid out last. Probably going to end up with nothing. Preferred stock, I'll kind of skip over. They don't test too much, but just know the difference between common stock and preferred stock. Like I said, preferred stock has liquidation priority. Preferred stock does not have voting rights, right? Preferred stock, why do people buy preferred stock? Because preferred stock has dividend priority. Preferred stock gets paid dividends before common stockholders. Now, common stock is probably going to go up in value more. Preferred stock is more safe and you'll get more dividend payments. So preferred stock, let's see, preferred stock has no voting rights, dividend payments are fixed. Common stock has voting rights and dividend payments fluctuate. Common stockholders can only get dividend payments after preferred stockholders have been paid. And then they have equity, they earn dividends, they perpetually hold, and they're liquid assets. Are we good with preferred stocks versus common stock and just what a stock is? A stock is ownership in a company. You own a company via having stock. That's how you can invest in a corporation. You can also invest in a corporation via bonds. Bonds are debt. Does everyone know the difference? I kind of want to take the screen off real quick. Between debt and equity? Let's talk about that. If you have equity in a company or you're a debtor to a company or you're a creditor to a company, what are the differences? Having equity in a company means you own a piece of the company, like a stockholder. If I have 10 shares of Ibis Prep company, I own 10% of Ibis Prep, right? If I have stock in Ibis Prep, I have equity. I have ownership stake. On the contrary, let's say I lend Ibis Prep money and I know that Ibis Prep is going to pay me money back plus some interest. Now that's debt, right? I have a debt instrument. It's debt because you don't actually own a piece of Ibis Prep. You don't have equity stake. You are a creditor, and Ibis Prep has become a debtor who owes you money. In the corporate world, how do you become a creditor of a company? Bonds, right? Think about stocks versus bonds. Stock is ownership stake in the company. Bonds is lending the company money with the agreement that they're going to pay you back the full principal plus interest. Now, if you guys really want to be smart at the conversation of business, a preferred stock is kind of that middle ground instrument because it is ownership stake in the company, true, but it's also pretty safe and pays dividends. Just like bonds pay interest, preferred stock pays dividends. So in a sense, preferred stock is kind of like a medium ground between equity and debt. But in our law school brains, let's just understand common stock, preferred stock is equity stake, ownership in a company. You have voting rights if it's common stock. Debt in a company is going to be like a bond. You lend the company money and they're going to pay you back. They're the principal plus interest. I just want to kind of slow that down and share. I don't think we need to know too much about this, but just know that bills, notes, bonds, those are all different terms for debt, right? Bills are very short term, notes are medium term, bonds are super long term. So that's the difference between stock and bonds. All right, let's talk about corporate management. This is an important slide. This slide must be known. The stock and bonds conversation is more honestly just like, so you don't get brain, they don't just throw questions over your head. You do have to have some understanding of how corporations work. Now let's talk about corporate management. So there's a board of directors, the BOD. They usually hold position for 1 year and are elected at the annual meeting of shareholders. Remember, common stockholders vote for the BOD. In Florida, directors must be natural persons over the age of 18. Not necessary to be a Florida resident, right? Very important. In Florida, the majority of directors constitutes a quorum. That's the number needed to hold a meeting. You have to have a quorum to hold a meeting in Florida. That's the majority of directors. Directors and officers of the corporation have a fiduciary duty to act in the best interest of the company. They must act in good faith, with the same degree of care and skill as a reasonably prudent person in the same position, and in a manner reasonably believed to be in the best interest of the company. Now, just like we discussed in trust with the prudent investor rule and how they're protected by the business judgment rule, same type of thing. They're going to be protected by business judgment rule here, because the understanding is I'm on the board of directors of Ibis Prep. Let's say I decide to cut California bar tutoring, and you guys are like, why would you cut California bar tutoring? There's so much opportunity in California. And I'm like, because there's too much competition, whatever. And then it turns out that it would have been a great decision and we should have, gone to California and we lost a bunch of money. You guys shareholders will not be able to sue me because I made the best decision standing in my shoes with the information that I had. And we're always going to assume that the board of directors, those people have better information than you. And so they are able to buy Bitcoin and lose $1 million in a day and it was worth the risk type thing. You know what I mean? You really have to show some bad faith to hold these people liable. The corporate opportunity doctrine is for sure. Directors and officers may not exploit information or opportunities acquired or made available because of the corporate position for personal gain unless the corporation has, after full disclosure, declines to pursue the opportunity or the corporation is unable to exploit the opportunity even with reasonable efforts. So the board of directors is responsible for the organizational performance. They set out the rules of the company. They make annual budgets. They're responsible for the compensation arrangement of top officials, and they elect the CEO of the company by casting their votes. Some of these rules and regulations, again, vocab words that we see, securities, the Prospectus Act, the Paper Act, it means that if you are registering to go public, you have to provide a prospectus, which means that people will be able to read up about your company. If Ibis Prep is going public, we're having an IPO or an APO or an SPO. This is an initial public offering, alternative public offering, or subsequent public offering. Then I would need to provide a prospectus. You don't really need to know about these two things right here. This definitely insider trading. Just know when it comes to insider trading, there's the tipper and the tippee, and anyone can be held liable if they acted upon insider information. That's knowledge that the public wouldn't have known. So if I'm in a board meeting and I hear we're about to lose a bunch of money, and I tell Tommy we're about to lose a bunch of money, and then Tommy sells his shares, I'm liable and Tommy's liable, right? Like, that was a messed up situation. Now, if I tell Tommy and Tommy doesn't act upon it, then Tommy's not going to be liable. I could still be liable for sharing the information, but he's not going to be liable for acting upon it, right? You have to act upon it. If you hear these words, Sarbanes-Oxley, another word you might hear is Dodd-Frank, right? Those terms, Sarbanes-Oxley and Dodd-Frank, those were legislation that came about in the 2000s, basically in response to Enron and then in response to the 2008 crisis, which basically just mean that these companies have a duty to have procedures in place that are strict accounting procedures so that there's no, crazy things going on in terms of like laundering money, right? They're like anti-laundering money. They have to have compliance. That's the word I'm looking for. They're about having compliance procedures in place. So if you ever see those words, Dodd-Frank or Sarbanes-Oxley, that's what those laws are referring to. And then blue sky laws, if you ever see that word, blue sky laws are referring to state regulations. Like it's states that have to like, under the blue sky laws, Florida has to have certain regulations. If, let's say Ibis Prep is only going to sell securities in the state of Florida, they still have to conform with the blue sky laws, which are similar to the federal laws. These laws are handed down by the SEC, the Securities Exchange Commission, by FINRA, the Federal Industry of National Regulation of, I have no idea what FINRA stands for, but FINRA and the SEC, these are the agencies that hand these things down. All right, let's move forward to mergers versus consolidations. So mergers and consolidations is when a company, a corporation, is going to merge or consolidate with another corporation, right? Consolidation is when two or more corporations combine into a new corporation, right? Whereas a merger is when one company absorbs another company. Think of Pac-Man and a merger. Pac-Man is when we are taking over this company. Consolidation is like Valentine's Day, we're making love and forming a new company, right? You've probably seen like Louis Vuitton Moet Hennessy, right? LVMH. I'm sure that they didn't start off separate. I mean, as LVMH, I'm sure Louis Vuitton merged, or not even merged, consolidated with Moet Hennessy. I don't know the specifics of that deal. I don't really shop at designer brands that much, but that is probably, if we can just, without knowing the details, consider that a consolidation, right? LVMH consolidated to form LVMH. Now, if it would have been a merger, it would have been more like, I don't know, because anyone think of a recent merger where one company just took over another company and I don't hear from them? I think you're on mute, Joel, but.
Sorry. Didn't that recently happen with like T-Mobile Sprint?
Yeah, I was thinking about, Sprint. They're gone.
No longer exist, right? It's just T-Mobile.
Perfect. T-Mobile merged with Sprint, and now it's just T-Mobile. So there's different forms of mergers. Statutory merger. When one corporation is acquired by the other, the target company is absorbed. The plan must be adopted by the board of directors and approved by shareholders, right? We get to vote on the board of directors. A short form merger is when you already basically own the company, like, I don't know, maybe like Facebook and Instagram. Let's just pretend Facebook, this is not true, but Facebook already owned Instagram and then they just short form merged. You wouldn't need shareholder approval. Triangular merger, this can be confusing, but just think about when one company creates a new company, a subsidiary, and then they merge that subsidiary with another company, and then they merge that company together. So it's basically like creating a subsidiary to take over a new company. So acquiring company creates a subsidiary, which is merged with the target company. If a subsidiary survives, right? So like we created a new company, like Gap created Gap Junior, and then Gap Junior took over Adidas and it stayed Gap Junior. That would be a forward triangle merger. If Gap created Gap Junior and then Gap Junior was taken over by Adidas, that would become a reverse triangle merger. Very confusing, but just let's learn to see these terms. Mergers, consolidation. De facto merger, when one company buys all the shares of another company, the surviving company is liable for all debts of the target company. The shareholders receive the rights of the statutory merger, right? So that's basically like, I think Elon Musk tried to do that with Twitter. I don't know if it ended, like, again, I'm not trying to dig into these details. It's always more confusing than it sounds in business, trust me. But sounded like it. That's how Elon took over Twitter. He just bought all the shares. He's like, oh yeah, see, I'm the boss now. And then a share exchange. When some or all of the shares of one company are exchanged for some or all the shares of another corporation. However, neither corporations seek to exist. So we just trade some companies. Shareholders are entitled to appraisal rights. Whenever there's a merger consolidation, shareholders are like, hey, what's that company worth? You guys are going to take over this company? I want to know what it's worth. Tender offers and takeover defenses. Tender offers an offer of cash or securities to the shareholders of a corporation in exchange for their shares at a premium over the market price. Must be public purchase of more than 5% of shares. There must be open disclosure of purpose. The offer must remain over 20 days and equal treatment. So a tender offer is just like, I'm sure that's truly what happened with Elon Musk and Twitter. he gave them a tender offer and say, hey, I'll buy it. And I think he did offer to buy it above the share price. And then takeover defenses are more hostile. It's like Elon Musk is just taking over Twitter, whether they like it or not. And these are some defenses that, again, just words you could see. The poison pill. The board of directors can classify certain shares as poison and give other shares rights warrants in the form of conversion rights or redemption rights, saying like, okay, you can take these shares, but if you take these shares, you're not going to get, those shares are kind of shitty. Like that's what a defense against a takeover. Restructuring defense, where they offer cash or securities to current shareholders, can be leverage buyouts or recapitalization. So these are ways that you can, use your current shareholders to defend. Again, I'm just flying over these things. Lockup, selling a major interest in the company to a favored bidder without shareholder approval. And then a self-tender. The target company makes an offer for its own shares, which drives the value down. These are just some terms that we can look at. This is important because there's differences between the way that a partnership and a corporation cease to exist, right? So let's learn these terms. Liquidation is when the corporation terminates its corporate business. Dissolution is when a corporation ceases to exist as a legal entity. Voluntary dissolution involves a proposal by the board of directors or shareholders and a filing of the articles of dissolution. And then involuntary dissolution is when it's ordered by a court or Department of State. So how do you, end the company? Proprietorship, it depends on the proprietor, just end it however you want. A partnership, a change in composition dissolves the partnership. A corporation, upon decision of the shareholders through voting. And then LLC, a change in composition dissolves the LLC. So dissolution, liquidation, more terms. Go over some recaps of the corporation. I know a lot over your head. Again, this afternoon is going to be where we tie it all together. I just wanted to, what's a corporation? It's a separate entity that has limited liability, right? C Corp subject to double taxation. S Corps are, you elect to be an S Corp and you have that flow through taxation. Closed corporations, 35 or fewer shareholders. That's what a closed corp means. Corporations must file articles of incorporation. Corporations have bylaws and hold annual meetings. A security, someone asked me that recently. A security is a tradable financial asset. So this gets confusing because we do commercial paper as a written essay subject, and they say that commercial paper is a medium of exchange for cash that does not include, a medium of exchange for money that does not include cash or securities. And someone asked me, what's a security? In general language, a security is stock or bond. That's just the easiest way for law students to think of a security, a stock or a bond, right? So they can issue securities. We teach for the Series 7 and we put ads out on the internet, so not anymore, but I need a teacher and I teach for the bar. For the securities, hey, we're looking for a security instructor. I used to get security guards. They'd be like, hey, I'm 6'8", and I used to beat people up outside of Monty's. And then for the bar exam, we're looking for a bar instructor. I used to get bartenders. Hey, I used to serve, I can make a mean cocktail. I'm like, oh Lord, did you guys not read the description of the job at all? But just an aside. Okay. Corporations can issue debt, principal plus interest or equity ownership stake. Bonds, notes, bills, debentures are debt, while common and preferred stock are equity. This word debenture is like a really bad unsecured debt. Don't invest in debentures. It's like a junk bond. Common stock has voting rights with junior liquidation priority. Preferred stock has dividend priority over common stock and liquidation priority. Debt has liquidation priority over equity. Wages, taxes, bond, debentures, preferred, common stock, right? Remember that hierarchy of priority. Common stock is getting paid out last in liquidation. Cumulative voting benefits the smaller investor by allowing them to pool votes together for one share. If you see the word cumulative next to preferred stock, it's just a way of getting missed dividend payments in arrears. But 98% chance the word cumulative is going to come up on the exam as cumulative voting, which means stacking all your votes for the one share. And they try to be like, hey, can you do the math? How many, it's not that hard, right? It's not that hard. We'll do some questions. Okay. Whenever they give you math on the bar exam, that's an easy question in my opinion. Because they have this idea that lawyers never took a math class in their life. The Securities Act of 1933 requires registration with the SEC and the filing of prospectus. Mergers result in a takeover. Consolidations result in a new company. Tender offers are offers to buy shares at a premium. The target company has takeover defenses. corporations reach their final stages through the processes of liquidation and dissolution. Any questions about corporations before I move on to partnerships? We're going to go over a lot this afternoon. I just want a general, like, what's a corporation? It's a big company. Ibis Prep right now is an LLC. We want to become a corporation one day, but when we become a corporation, people are probably going to not like us so much because corporations have bad reputations because they're big entities, right? Like, that's just the way it is. Partnerships are, a little bit more chill, and they're like smaller. Let's look at partnerships. So a partnership is an association of two or more persons to carry on as co-owners of business for profit. It's governed by RUPA, the Florida Revised Uniform Partnership Act. A partnership is a flow-through entity. All gains and losses flow through to the partners for tax purposes. Partners owe each other, and the partnership, the duties of loyalty and care, the fiduciary duties, very similar to the trustee duties, right? Like, these are business people duties. You got to be solid in business. Two or more persons and co-ownership in business for profit. That's a partnership, right? Partnership formation. A partnership is formed when two or more people engage in a business together with the intent to create a profit, right? Very different than a corporation. Can anyone remind me how we create a corporation?
Articles of incorporation. Exactly.
You have to file with the state. I'm drinking corporate juice right now. Watermelon juice from Starbucks. Yeah, corporate juice. I like watermelon, it's just not corporate juice. Partnership agreements are typical partnerships, but may not eliminate duty of loyalty or unreasonably reduce duty of care, right? You can't say, hey, me and Tommy are going to be partners, but Tommy has no duty of loyalty or care to the partnership. You should have a partnership agreement. You as practicing attorneys, honestly, I think this type of law is a great entry into law for young people who are just trying to get some work, because you can help people start up their businesses, right? People want to become LLCs, or people want to start a partnership. Hey, I'll do the agreement for, what I mean? It's a very, like, their business doesn't have to work. You don't have to invest in their business. You just have to create the contracts, and it's good to know. So I would recommend, if your friends are trying to start a partnership, to create a partnership agreement. I would also recommend giving them the options. Do you want to do an LLC? Do you want to do an S Corp? Do you want to do an LLP? Or there's a whole lot of options. So it's good stuff to learn. A voluntary partnership registration statement may be filed with the state. Maybe, doesn't have to be. The sharing of profits is prima facie evidence of intent to form a partnership, right? The sharing of profits. Just because, I start Ibis Prep, let's just assume, and I want to get things started. So I go up to my friend Tommy. I say, yo, Tommy, let me borrow $100,000 to start Ibis Prep. He's like, all right, bet. And he gives me the money. Is he my partner? I'm going to pay you back plus interest. Is he my partner? Tommy lends me $100,000 to start Ibis Prep, and I'm going to pay him back plus interest.
No. Well, I would say no, because there's not necessarily an intent to create a profit.
Right. No, Sam's saying no. We're all saying no. That's a key point. It has to be intent to share profits, not to just lend someone money and pay them back. But if me and Tommy, we're talking in the bar one day and we're like, yo, dude, let's start a business. We'll be tutoring. It's going to be sick, bro. And then the next day, I tutor someone and I call myself Tommy and Andrew Tutoring Company, then we're a business. We've intended to share the profits. I got to give them 50% of whatever I'm profited on that tutoring company. Maybe I pay myself for the time served, but whatever profit we made would be split, because just us at the bar. Now, maybe there's an argument that we didn't have the capacity, but still there's a presumption that two people intending to split profits create a partnership. Written in partnerships are required for partnerships that cannot be completed in 1 year, and partnerships that deal in real property. We see that come up in trust too and everything. A partner cannot compete against a partnership without consent of all partners, right? That's the loyalty thing. Partnership by estoppel. Here it comes up again, our favorite word. If a person represents herself as a partner in a partnership, the person can be estopped from denying liability or holding himself as a partner. We saw corporation by estoppel too. That answer comes up a lot. Like, if the person thinks that you guys are a partnership, you're probably going to be held to being a partnership, unless it was like totally unreasonable. Now, if we look at partnership dissolution, it's a little bit different. It's a little bit more complex, actually, than partnership. dissociation, liquidation and dissociation. Here we have dissolution, winding up, termination, and dissociation. Liquidation and dissolution for corporations, dissolution, winding up, termination, dissociation. So we would just add liquidation, dissolution, and call it a day with corporations. With a partnership, dissolution, the point when the partners cease to carry out business. Winding up, the process by which a partnership's assets are sold, its debts are paid, and any balance left is distributed to the partners. Termination, after the process of winding up has been finished. Disassociation, the process of a partner leaving a partnership, automatic by death or bankruptcy. Disassociation of a partner does not automatically dissolve the partnership, right? There's 3 partners, just because one partner disassociates. Now, there's some questions where it's like, can you still be held liable after you've already disassociated from the partnership? And it's very fact specific. You know, if you have, there's reason to believe that, you know, you still had involvement in the company, or your actions prior to it led to these debts, you know, potentially. You're not going to be liable for new business, though. If they get a new client after you dissociated, now they've done something stupid, that's not going to implicate you. So dissolution, new partnership, winding up, termination, right? You can form a new partnership, or you could wind up and terminate. And then someone could dissociate. So let's talk about different types of partnerships. And this is pretty much it that for this, you know, business entity section. Again, we'll go over a lot of details this afternoon, but let's just talk about different types of partnerships. An LP, a limited partnership has limited general partners. General partners are subject to personal liability. Limited partners are liable to the extent of their investments and have no management responsibilities. Limited partners must file a certificate with the state. The LP must include limited partner, LP, or limited. So if we just have a general partnership, that's the simplest, like me and Tommy are general partners. We have all the limited liability. We're on the hook for everything. We're just super basic. An LP is when someone is going to be a limited partner. There has to be at least one general partner of an LP, right? If I were to form Ibis Prep as an LP, I'd be the general partner. I'd take care of everything. And then I'd bring on some limited partners. Limited partners are liable to the extent of their investment and have no management responsibilities. LPs must file a certificate with the state, and they must include limited partner, LP, or limited. So the management is by the general partner. General partners will always have unlimited liability and management duty. They have fiduciary duty of care and loyalty. Where the limited partners, they're not an agent of partnership. They have no management. They're just people giving you money, right? They could lose all their money, but nothing more than that. A limited partner, no company involvement, no daily responsibilities, no liability. A general partner oversees the company, responsible for daily operations, full liability. They both own part of the company, and they both receive a share of the profit. Again, if it's silent, 50-50 on profits. But the partnership agreement will always dictate everything. Just like the articles of a corporation will always dictate everything. If they're explicitly written, that's what we're going to usually look to. Now, an LLP. So what's the difference between an LLP and an LP? Well, an LLP doesn't require us to have this general partner, right? We can all be limited partners in an LLP. So they can all be limited partners and have limited liability. I think this is actually a misnomer. So LLP files a statement with the Department of State. The partnership must include registered limited liability partnership, RLLP, LLP, RLLP, or LLP. Must file an annual report. The LLP shield protects a partner only from the liability of the malfeasance of another partner. It's a good option for professionals who work together, like medical practice. It's like an LLC, but still subject to flow-through taxation and not a separate entity. So an LLP is a hybrid of a corporation and a partnership. It's registered in a limited liability partnership. Individuals or body corporate can be partners. So, right, like you can have a partner who's Nike. Nike could be a partner in LLP. The definition of person in the income cap now includes an LLP. So an LLP is like recognized as a person under the law. These are recognized, under the law as an LLP. So everyone in this LLP has limited liability. That's why they say it's good for a medical malpractice. We're all part of Ibis Medical, but I'm a doctor who does my stuff. Tommy's a doctor who does his stuff. I'm not going to be liable for what Tommy does. No one will be liable for anyone else, right? So that's an LLP. A limited liability company, an LLC, like Ibis Prep LLC, Articles of incorporation must be filed with the Department of State. They must have a lawful purpose. It must have a limited liability company, LLC or LLC in the name. LLC is a member managed company unless designated as manager managed. Member managers are limited duties of loyalty and care. And LLC is act as a separate entity. And this presentation is brought to you by Emoji Face, Ibis Prep LLC. So look at the Partnership Corporation LLC. Partnerships, they pay tax only once. The owners are liable. LLCs, they pay tax only once. Limited liability. Corporation, limited owner liability, but double taxation. That's why most businesses, small businesses, are LLCs or S corps. And like I said, if I could go back in time, knowing how my business was going to grow, I would have done an S corp. But I could just elect it next year. You know, it's just an election. It's not really a real thing. Real things are corporations and partnerships. These things are more of elections that they're creatures of the law, let us say. So let's look at this comparison of business forms. So general partnership, no formality required. Limited partnership, you have to file a certificate of limited partnership with the appropriate state office. LLC, you have to file articles of incorporation with the state. And LLP, registration of LLP is filed with the state government. For general partnership, the liability, unlimited of each partner for the firm. For limited partnership, the general partners have unlimited liability for firm debts, and the limited partners have no liability beyond the loss of their investments, right? That's for an LLP. That's for an LP. For a LLC, all members are liable for the LLC debts to the extent of their capital contributions and equity in firm, no personal liability beyond such. For an LLP, no liability for partners beyond their contributions and equity in the firm, except unlimited personal liability for their own wrongful acts and those of persons who they supervise. So LLP, think of the doctor's office. LLC, think of Ibis Prep. Limited partnership, think of you and another person, but you're just an investor. And then general partner, think of you and Tommy selling lemonade. Management, LGP, all partners according to the partnership agreement or the UPA RUPA, let's say RUPA. Limited partnership, general partners manage it according to RUPA. Limited partners do not manage. Who manage an LLC? Members of the firm, or who may they delegate authority to managers, right? And then LLP, all partners according to the partnership agreement or RUPA. Dissolution as set forth in the partnership agreement or RUPA, set forth in the partnership agreement for RUPA for an LP, as set forth in the LLC statute or articles of incorporation, as set forth in the partnership agreement or RUPA. So partnership agreement is going to be very important, or articles of incorporation. That's going to really dictate how most things goes. And if it's silent, then it'll be by statute. Another one is a PC, Professional Service Corporation. My uncle's firm is a PC. You see it a lot for law firms. It's kind of similar to LLP, but some little differences. Mostly that it's a professional service. So it can be a professional service corporation or professional limited liability company. Members of these chartered companies receive limited liability for debts and limited liability for the malfeasance of others, right? So it's like in the doctor's office where, you know, you have limited liability, but for the malfeasance of others too, and for debts, for everything. It must contain the words chartered. There are types of professional service that can receive the designation: accountants, physicians, chiropractors, dentists, veterinarians, attorneys, life insurance agents. A PLLC is kind of an LLC specifically designed for licensed professionals. The difference between an LLC and a PLLC is mainly that only licensed professionals such as architects, doctors, lawyers can form them. So I kind of confused there about that. A PC is not so much like an LLP. It's more like an LLC where it has limited liability and you're not liable for anyone else in the firm. You know, it's like you're not even liable for, you're really taxed as a separate entity. It's basically an LLC. It's just they're chartered, they're for professional companies. Again, that's a good question. If you're starting a business, what do you want to be? LLC, LLP, LP, GP, S Corp, corporation. Just understand the main differences between them. So 3 things, if we only know 3 things for this. Sole proprietorship is a one-man band, owned by the manager, one person, unlimited liability, single entity. Partnership, 2 or more people, no separate owners, unlimited liability, it's not a separate entity. Corporation, 5 or more shareholders, They're separate, limited liability, and separate entity. You didn't come this far only to come this far. Super good point. I'm just gonna show everyone a few more things before we take a break and go to Will's. And again, we'll come back to a lot of it this afternoon. But we have an outline here called reduced business entities. Let's see if we touched on some things or we missed on some things. Definition of a partnership, right? No formal agreement, sharing of profits, duty of loyalty, duty of care, a little bit about their liability, and all partners are liable for the contracts in the scope. Liability is joint and several, but you're not liable for the criminal acts of another partner unless you participate. Distribution order, creditors, including partners who are creditors in the partner accounts. Limited partnerships we talked about. GPs versus LPs, the rights of the partners, the duties of the partners, and all these things. We talked about LLPs. And then, yeah, pretty much just different types of partnerships. For corporations, how they're taxed, as an entity, double taxation. These are the obligations. Broad corporate powers. They're liable for punitive damages for intentional misconduct or gross negligence. These are the things that must be on the articles of incorporation, but it may have the number of directors, par value of the stock, and the initial purpose. We talked about the difference between these types of corporations, different doctrines. Oh, I didn't mention this, the Deep Rock Doctrine, when capital contributions are denominated loans. Basically, that means that if you can pierce the corporate veil because the people who are investing in the company are not really owning the company, they're just giving you loans. Thin capitalization, if it's very undercapitalized, is another way of piercing the corporate veil. And then subsidiary, like I said up there, a subsidiary company. We talked about ways to pierce the corporate veil. Agreement to buy stock, a subscription agreement, subscribers agree to purchase stock, consideration for shares, shareholder liability, security laws for non-exempt security registration filed with SEC, and then preemptive rights, first right of refusal for new shares. Anything, section B6, I didn't really mention these too much. If you're a 10% shareholder, then the director has to return any profit from the sale of stock within a 6-month period, because that makes you a control owner. If you're a control owner, then you basically have so much of the stock that you have a no sale clause for 6 months. Rule 10b-5 prohibits fraud and deceit of material facts concerning shares. Talk about the insider traders. The Williams Act imposes anti-fraud and disclosure requirements when tender offer is made for more than 5% of shares. Blue sky laws, right? Talk about those are state-specific laws. Promoters, liable in contracts entered on behalf of a corporation, even after the contract is adopted by a corporation, unless a novation is signed, which removes liability to a promoter. We'll do a question this afternoon about a promoter. Shareholders, they have, they can look at the board rights, they can look at the balance sheet, do they inspect certain things. We talked about derivative suits, who can be on the board of directors, duty of loyalty, duty of care, corporate opportunity doctrine, Sarbanes-Oxley, mergers, dissolution. So how to dissolution, you file notice with the Department of State. Within 10 days after adopting articles of dissolution, you publish notice once a week for 2 weeks with newspaper of county where the corporation has principal address. The Florida statute provides that dissolution shall not impair remedy if the action is commenced against a corporation within 3 years after dissolution. And then a non-for-profit corporation does not distribute income to directors or officers. The board of directors must consist of 3 or more individuals. So, ladies, gentlemen, non-binaries, artificial intelligencers, hope you enjoyed the first part of class. Mainly, I just wanted exposure to what's a corporation, what's a partnership, what are some of the different types of partnerships, and what are some of the key characteristics of corporations. If that's all you got from today's lecture, that's fine.